Persons. A person refers to any being, physical, moral, real, juridical, and legal, susceptible of rights and obligations or being the subject of legal relations. Personality is the aptitude of a person of becoming the subject of legal relations, inherent in every natural person and is lost only through death. Status. Status is the legal condition or class to which one belongs in society, or the legal or juridical position of the individual in society, which determines the nature and number of rights of an individual. Status can be political and civil status can be grouped into three classes. 1. As a member of society. A. Resident or non-resident. B. Citizen or alien. 2. As a member of the family. A. Single, married, widow, divorced. B. Parent, child, brother or sister. C. Legitimate, illegitimate, adopted. As himself. A. Age, whether minor or major. B. Sex, whether male or female. And C. Mental condition, whether sane or insane. Article 37 of the Civil Code, juridical capacity, which is the fitness to be the subject of legal relations, is inherent in every natural person and is lost only through death. Capacity to act, which is the power to do acts with legal effect, is acquired and may be lost. Juridical capacity can exist even without capacity to act. The existence of the latter implies that of the former. Full civil capacity is the existence of both capacity to act and juridical capacity. Capacity and incapacity depends on law, whether or therefore it cannot be modified by agreements. It is a matter of public interest. So how are juridical capacity and capacity to act different? Juridical capacity is the fitness of a person to be the subject of legal relations. Capacity to act is the power to do acts with legal effects. Juridical capacity is passive. Capacity to act is active. Juridical capacity is the aptitude for the holding and enjoyment of rights. Capacity to act is the aptitude to enjoy or exercise rights. Juridical capacity is inherent in natural persons, while capacity to act must be acquired. Juridical capacity is lost upon death, while capacity to act is lost through death and other causes. Juridical capacity can exist without capacity to act, while capacity to act must exist with juridical capacity. Juridical capacity cannot be limited or restricted, as opposed to capacity to act, which may be restricted or limited. What are the kinds of persons? Persons could be natural or juridical. Natural persons refer to individuals or human beings who are created by procreation. Juridical persons are artificial, abstract, and created through laws. More on natural persons. Article 40 provides that the conceived child shall be considered born for all purposes that are favorable to it, provided it be born later with the conditions specific in the following article. That is, the fetus be alive by the time it is completely delivered from the mother's womb, as defined under Article 41 of the Civil Code. This proviso, however, is not a condition precedent to the right of the conceived child. For, if it were, the first part of Article 40 would become entirely useless and ineffective. From the case of Kimiging versus Ikaw, 1970. What are the characteristics of fetal personality? They are limited, provisional or conditional, and can enjoy rights. Limited because it only has rights for the purposes favorable to it. Provisional or conditional because it should be born alive later before the rights can be claimed. And 3, can enjoy rights inherent from will or intestacy and given donations even before birth. The conceived child has provisional personality for all purposes favorable to it. 1, it is entitled to support. 2, it may inherit or succeed. And 3, it may receive donations. What is the period of conception? the first 120 days of the 300 days preceding the birth of the child. Article 41 of the Civil Code. For civil purposes, the fetus is considered born if it is alive at the time it is completely delivered from the mother's womb. However, if the fetus had an intrauterine life of less than 7 months, it is not deemed born if it dies within 24 hours after its complete delivery from the maternal womb. Birth. Birth is the removal of the fetus from the mother's womb, which may be done naturally or artificially by surgery. Before birth, the fetus is not a person, but a mere part of the internal organs of the mother. But because of the expectancy that it may be born, the law protects it and reserves its rights, making its legal existence, if born alive, retroactive to the moment of its conception. The presumption is that the baby was born alive, and the burden of proof lies on those who allege the contrary. So, based on Article 41, a child is considered born if it has an intrauterine life of 7 months or more. It is considered born if it is alive. If ang intrauterine life is less than 7 months, it is considered born if alive after completion of 24 hours from delivery. So, meaning if less than 7 months, and then within 24 hours from the time it is born, mamatay, dili ka considered nga alive. Since birth determines personality, an aborted fetus never acquired legal rights or civil personality because it was not alive at the time of delivery from the mother's womb. No damages can be claimed in behalf of the unborn child, since an action for pecuniary damages on account of personal injury or death pertains primarily to the one injured. This is not to say that the parents of an aborted fetus are not entitled to collect any damages, but such damages must be those inflicted directly upon them as distinguished from the injury or violation of the rights of the aborted fetus. Example, moral damages for loss and disappointment of their parental expectation from the case of Gelus versus E.E. Death. Article 42 of the Civil Code. Civil personality is distinguished by death. The effect of death upon the rights and obligations of the deceased is determined by law, by contract, and by will. Only natural or physical death. The law does not recognize civil death, that is, death due to conviction or a religious profession. For certain purposes, after the death of a person, his personality continues in his estate. The estate of a deceased person is considered as having legal personality, independent of the heirs, wherein the mass of property, rights, and assets left by the descent becomes directly vested and charged with his rights and obligations. Criminal liability ends with death, but civil liability may be charged against the estate. Article 43 of the Civil Code. If there is a doubt as between two or more persons who are called to succeed each other, as to which of them died first, whoever alleges death of one prior to the other shall prove the same. In the absence of proof, it is presumed that they died at the same time, and there shall be no transmission of rights from one to the other. The statutory presumption provided in Article 43 of the Civil Code provides only when there is doubt on the order of death between persons who are called to succeed each other. It does not apply when there is credible witness as to who died first, from the case of Joaquin versus Navarro, 1953. So, Article 43 of the Civil Code versus Section 3 sa paragraph JJ Rule 131 of the Rules of Court. How are they the same and different? Both Article 43 of the Civil Code and Section 3, subsection JJ Rule 131 states that refers only use the presumptions when there are no facts to get inferences from. So how are they different? Article 43 only used for succession purposes. Ang Rule 131 of the rules of court cannot be used for succession purposes. Article 43, any circumstance, ang Rule 131, only during death in calamities, wreck, battle, or conflagration. Article or Rule 131, Section 3, subparagraph JJ, provides that if there are no inferential circumstantial evidences to be inferred from, it can be presumed that when two persons perish in the same calamity and it is not shown who died first, the survivor is determined from the probabilities resulting from the strength and the age of the sexes. So Section 3, subsection JJ, Rule 131 of the Rules of Court, presumption of survivorship. Okay. So, kinsa ang presumed to have survived between deceased A and B? If deceased A is under 15, while deceased B is under 15, the one presumed to have survived will be the older one. If deceased A is above 60 and deceased B is above 60, ang younger ang presumed to have survived. If deceased A is 15, deceased B is 60, ang presumed to have survived is under 15. If deceased A is above 15 but under 60, of different sexes, and mao po si deceased B above 15 but under 60 of different sex, siguro male and female, the one presumed to have survived is ang male. If deceased A is above 15 but under 60, same sex, para sila male or para sila female, and in B pod, the one presumed to have survived is the older one. If deceased A is under 15 but over 60, under 15 but over 60, and deceased B is between 15 and 60, the one presumed to have survived is ang between 15 and 60. Juridical person. A juridical person is an abstract being formed from the realizations of collective purposes to which the law has granted capacity for rights and obligations. The entity must be recognized as having its own rights and obligations which are not that of its component members. Its personality is manifested only in the realm of patrimonial relations. It has no family and personal rights. The following are juridical persons under Article 44 of the Civil Code. 1. The state and its political subdivisions. 2. Other corporations, institutions, and entities for public interest or purpose created by law. Their personality begins as soon as they have been constituted according to law. A. These are governed by the laws creating or recognizing them. B. Upon the dissolution of the corporations, institutions, and other entities for public interest or purpose, their property and other assets of law, or the charter creating them. If nothing has been specified on this point, the property and other assets shall be applied to similar purposes for the benefit of the region, province, city, or municipality, which during the existence of the institution derive the principal benefits from the same. Third, juridical person are corporations, partnerships, and associations for private interest or purpose to which the law grants a juridical personality, separate and distinct from that of each shareholder, partner, or member. A. Private corporations are regulated by laws of general application on the subject. B. Partnerships and associations for private interest or purpose are governed by the provisions of this code concerning partnerships. Juridical persons may 1. Acquire and possess properties of all kinds. 2. Incur obligations. 3. Bring civil or criminal actions. Juridical persons are not completely at par with natural persons as to capacity because it cannot exercise rights which presuppose physical existence such as family rights, making wills, etc. But like natural persons, it has a nationality, a domicile, a right to Reputation. It can own and possess property, dispose such property, enter into contracts, or inherit by will. It can also incur obligations. Capacity to act. Article 37 of the Civil Code, juridical capacity, which is the fitness to be subject of legal relations, is inherent in every natural person and is lost only through death. Capacity to act, which is the power to do acts with legal effect, is acquired and may be lost. Presumption of a capacity. Capacity to act must be supposed to attach to a person who has not previously been declared incapable, and such capacity is presumed to continue so long as the contrary is not proved. From the case of Standard Oil Corporation versus Aranas.